5, 4, 3, 2, 1. Hello, everyone. Welcome to the 18th International Conference on Artificial Intelligence and Law. My name is Roberto Bornhausen, and I'm a member of the local organizing committee from University of São Paulo. And this is the third panel of the second day of the event. I'm sorry about the noise here. We have this online conference with real problems. But first, I would like to present our sponsors of this panel. So first, I would like to present our platinum sponsor, Jus Brasil, which is currently the #1 law and government website worldwide with 28 million unique users each month that make high-value legal information super easy and quick to access, thus saving its users time and providing substance for their case strategies and insights. And also, I would like to present our hospital, Albert Einstein Israeli Hospital, platinum sponsor, which is the best known health units in Brazil and Latin America for the quality of care and the equipment and medical specialties available to treat main types of pathologies. The hospital is reference in treatments with state-of-the-art technology and humanized care, expanding its borders with social responsibility actions, teaching and research activities. Now, I'd like to present our speakers of this panel, which are first, Professor Juliano Maranhão, and second, Mr. Wachara. So now I'll pass the word to Professor Juliano Maranhão. Please, the floor is yours, Professor Juliano.
Thank you very much, Roberto, and good afternoon to all, or depends on the time zone. So hello to everyone. I'm going to present our paper now. I'm going to share the screen. Is it visible for everybody? Okay. So the paper is, the title of the paper is A Dynamic Model for Balancing Values. It's a joint work by myself, Juliano Maranhão, representing the University of São Paulo Law School, the Center for AI at the University of São Paulo, and the Logarithm Institute. And also Edelcio Gonçalves de Souza, a co-author, a colleague at the University of São Paulo and Logarithm, and Giovanni Sartor from the University of Bologna and the European University Institute. Our goal, our short-run goal in this paper is to model reasoning with rules and values. There is an apparent consensus that applying the law is not limited to applying rules, but also to apply rules in consideration of underlying values. There are at least 3 ways in which rules and values are interconnected in legal adjudication and legal reasoning. The first one is that values are a critical framework for assessing the merits of positive laws. That is, values are used as an assessment to the extent to which the rules meet some standards of justice and fairness, and therefore this may affect the validity of rules. There are different legal theories to approach what is the particular relation between law and morality and with respect to the validity of rules. The second way that values are relevant in the application of rules is it regards interpretation. So in interpretation, when the interpreter selects alternative meanings to legal terms, it considers underlying values and teleology, that is, the extent to which the rule, the meaning which is ascribed to the rule, better promotes or demotes relevant values of the community. And the third way in which values and rules are interrelated is regards the proportionality reasoning in constitutional and in human rights assessment. That is, if there is an infringement of constitutional right, this infringement is assessed with respect to advantages regarding other constitutional rights and fundamental rights and values, and it's assessed if there is a better trade-off in this conflict between constitutional values. So also here there is a choice between the underlying morality, public policies, or fundamental rights, which are relevant for the application of rules. So since these values are also relevant for interpretation, the long-run goal of this research is to contribute for the tenet of making the law computable, given that to providing logical models to represent law in a computable way. So this research is connected with, is a continuum with respect to previous research. The first one presented at ICAIL 2017, where we discussed a logical architecture for dynamic of legal interpretation. We were concerned with the interplay between changing rules and changing meaning ascription and changing values which are underlying those rules. Then in the 2018, a paper with Edelso Souza about the contraction of constitutional and regulatory, constitutive and regulative rules. Then Maranhão and Sartor in ICAIL 2019, we assessed how the balance of values may affect and change legal rules. And in Dion 2020, a paper with Sartor called Interpretive Normative Systems, we assessed different legal theories regarding the relation between law and morality. As a running example to our model, we have used the Riley versus California case judged by the US Supreme Court in 2014. According to the law at the time, police officers were permitted to access the content of any item found with the arrestee in an arrest. And then a new question was raised by this case, which was, is it permitted to access also the digital content of the arrestee's mobile phone? And the answer by the Supreme Court at this time was no, that is, the police must obtain warrant to search cell phones. And this was based on a consideration of underlying values. Specifically, it was argued that in this case, there is a significant impact on the privacy of the arrestee if the digital content of the mobile phone is accessed. So in the balance of values regarding safety and privacy, in this case, privacy would outweigh safety, and therefore it should be forbidden to access this particular property item of the arrestee. So we would like to model that, and in particular to understand how is this balance between competing values and how they affect legal interpretation. But we are going to focus on arguments about values which are demoted against values which are promoted by the action at stake. I'm not going into the details of the formalism.
This meeting is being recorded.
I'm not going to the details of the formalism, but I'm trying to show how the model works using the example given by Riley versus California. So the whole game here in this model is to compare those values which are demoted against the values which are promoted by the action at stake, given a certain constellation of factors. So we divide the values which are relevant within those which are demoted and those which are promoted, and use an impact function to assess whether the action impacts the demotion or the promotion of a given value, and also use factors that may intensify or attenuate the impact of such values. So the idea is that we compare the proportional impact on values with the proportional and aggregate impact on the promoted values. And if the demoted values beat the promoted values, then we have a reason to forbid the action at stake. Otherwise, we have a reason, if the promoted values are stronger than the demoted values, then we have, or equal to the demoted values, we have a reason to permit the action given that constellation of factors. And so there is also a connection with argumentation with this approach, since we know that the argument bringing values which are relevant and has some hierarchy within the field of underlying values to rules, and then arguing that actions may impact those values, are arguments to the fact that there is a reason to forbid a certain action, or there is a reason to permit this action. So we want to also to bring this argumentative dimension, but we model it by means of change functions. So let me give an example of the additive model that we have used. We have await functions taking values to the interval of real numbers 0 to 1, and they are going to represent dimensions of relative importance of these values and a hierarchy between the values at stake. And then unimpact functions that take factors and values and represent the impact, an impact function for each action, and it represents the impact of the action in the value, and actually the influence that factors may have on the impact of the action on such values. And this impact may be positive. This influence of the factors on the impact of the action on values may be positive, or it may be negative. If it is positive, we call the factor an intensifier. And if it's negative, we call the factor attenuator. Of course, one may argue that there is some arbitrary choice between the interval of real numbers that we assign to weight of functions and to impact of factors or of actions on the values. But actually, this is just a model to try to represent reasoning with dimensions and magnitudes. So any scale may be used to represent this impact. It can be an interval of 3 points, for instance, low, medium, and high. It could be of 5 points, low, medium, medium, high, and high, and so on and so forth. It depends on each model of representation that one would like to use. But the fact is that there is a rationality using this dimension, and that's what we want to capture. So here in the example, if we consider the impact of the action on a certain value, we call it a baseline impact if there is no factors to be considered. So in this case, in the Rilo versus California case, we are concerned with the impact of the action of accessing an item which is found with the RST. So accessing any item has a baseline impact of 0.4 on privacy, and privacy has some weight. The proportional impact is the product of the impact and the weight of the value. So here we have, in a baseline situation where there is no factor considered, we know that we have that the privacy, the impact on privacy of the action of accessing outweighs the impact on safety, since there is no charge against the individual, then the result is that the demotion of values is stronger than the promotion, so the action is forbidden to access. But we may consider intensifier factors. For instance, the factor that there is an arrest intensify the impacts on safety by the action of accessing. And therefore, if you consider the product with the relative importance of safety, we will have that the balance shifts, now making the action permitted in the case of an arrest. And if we move now for a consideration of property rights, the factor that there is a property now on the demotion of property rights, but it's not sufficient yet to beat the promoted values. And therefore, it is still permitted to access the items if there is an arrest and it's a property item. However, if we consider a mobile phone, then this is another intensifiers that intensify, as the Supreme Court said, significantly the impact on privacy. And this makes that the aggregate impacts on the demoted values becomes stronger than the aggregate impacts on the promoted values, which means that if there is an arrest, it is a property item, but it is a mobile phone, then the balance says that there is a reason to forbid the action of accessing the digital content of this mobile phone. But factors may have an attenuating influence on the impact of action on values. For instance, if we consider that the mobile phone is not a personal one, but is a professional one where only professional content is allowed, then this would attenuate the impact on privacy and may shift the balance again for an authorization to access the content if the mobile phone is not personal. So that's how the game is played within the additive model. But our main concern and contribution in this paper was to describe how the shifts of balance occur if we add factors, or if we contract factors, or if we add values, or if we contract, delete values from the model to be considered. And this may reflect argumentation so that there is a factor to the fact that there is a factor that was not considered, or to the fact that there is a factor that actually is not present, and therefore this will change and shift the resulting deontic status of the action at stake. So the goal was then to describe balance shifts by changing either the set of factors or by changing the set of values. If in this game we are concerned about who's going to win, is it going to be the demoted values or the promoted values in the balance? So if we consider a situation where the demoted values beats the promoted values, it makes the action forbidden, and we want to know now how this balance may be shifted. There are two ways, basically, in which this value may be shifted by the addition of new factors. It may be a strengthening of the opponent, that is, a strengthening of the promoted values, and we may strengthen the opponent by adding intensifying factors to it. We called it a factor rebutting expansion function. Rebutting because it looks like a rebutting in structural argumentation, since we're going to come with a new opponent to the argument and strengthen the opponent. So for factor rebutting expansion function, you add factors which intensify the impact of the action on the promoted values. But it may be an undercutting if we weaken the winner. And we do that by adding attenuating factors. Now, we also may shift the balance by contraction, by deleting some factors. So if we delete factors which attenuate the impact of the action on the promoted values, we have a factor rebooting contraction function, because we are deleting attenuators of the opponent. So we make the opponent stronger. But we may also delete intensifiers of the winner. So we may weaken the winner. This would be the case of a factor undercutting contraction function. So let me show how this could work in the example. Suppose we have this previous argument position, and then we have as values promoted privacy and values demoted privacy and promoted safety. And now we are going to add a new factor by a rebooting expansion function. This new factor increase the strength of the promoted values, and therefore it beated the previous argument position where the action was forbidden because the demoted values were stronger than the promoted values. Now we add that is the context of an arrest, and therefore this will activate the value of safety, and therefore it shifts the balance to a permission of the leading to a permission of the action in the context of an arrest. Now, to represent a contraction, let us suppose then that we have this as our previous position, and we delete the arrest and safety. So we had before that the promotion of values beated the demotion of values, making the action permitted. But now, if we delete the arrest and say that the arrest was invalid, or that there was not an arrest as an argument, this will shift again the balance, making thus the action forbidden. And this would be an undercutting contraction function, since it weakens the winner by deleting an intensifier. Now, suppose we have this as an original argument position, where we have that the action is forbidden because it's an arrest of a property item, in particular of a mobile phone, and we have that the aggregate impact of the values demoted are stronger than the values promoted. Now, if we expand the set of factors by the factor that is not a personal item, this will attenuate the aggregate impact on the demotion of values, weakening the demotion of values and making it weaker than the promotion of safety. This will then have an effect of shifting the balance, and since it is an addition of an attenuator on the winner side, we call it an undercutting expansion function. Now, if we consider this as the original position, and we want to delete the factor in question, then we would have that the attenuating factor of the opponent is deleted, and therefore this is a factor rebooting contraction function that shifts again the balance. I think we are ahead of the time. So with respect to with respect to the shifting of balance, we may also have the shift concerning the set of values. if we add values or if we contract or delete values, this may also lead to a shift of the balance, changing the reasons for a prohibition to reasons for a permission. This shift may be caused by a value rebutting expansion function. And what is that? If you add values promoted by the influence of intensifying factors. So if you strengthen the opponent by adding values, but you may also weaken the winner by adding values. And this will be a value undercutting expansion function. We may also have the effect of shifting balance if we use a value rebutting contraction function that is to delete an attenuating factor from, to delete a value which is promoted by the influence of an attenuating factor, or otherwise, if we have a value undercutting contraction function, if we delete values that are demoted by the influence of intensifying factors. So let me give, just to finish, an example of adding a value. Suppose we have this as an original position, and in this position, the promotion of safety beats the demotion of property rights. But then if we add into consideration the value of privacy, and we know that there is a baseline impact on privacy, then this will shift the balance by expanding the set of demoted values, by making them, since you strengthen the opponent, this is a value rebutting expansion function. And you may have an undercutting contraction function when you delete the corresponding value. And so on and so forth. These are the moves that may be described. In the paper, we have made a formal description of these functions in an AGM style. And the idea then is now to raise your interest to the paper by showing how it works in the model, but we didn't enter into the technical details. If you would like to know these technical details and the construction of these functions, please visit our paper in the proceedings. And I thank you very much for your attention.
Professor Juliano, thank you very much for your paper, your presentation. Now, I would like to pose a question from the audience. Mr. Rafael Saravalli has the following question to your paper. How could this model proposed by you represent analog reasoning?
Well, it is possible to represent analogy in this model. For instance, if you have, let us see that it's forbidden to, sexual abuse is forbidden, but it is permitted in the case of a pregnancy which is a resultant. Let us take an example of abortion. So it's forbidden to provoke abortion, but if this is the case of sexual abuse, then it's permitted to perform the abortion. Then this is the case because it impacts in this case, present this fact, there is an impact in woman dignities that outweighs the life of fetus. So we may use an analogy in this model by saying, for instance, that the case of an encephalic fetus is analog to the case of sexual abuse, because carrying the pregnancy in this case means significant suffering for the pregnant. So in this case, if you consider that this factor is an analog with respect to the impact on values, then we would expect to have the same solution by saying that it is permitted in this case, to perform an abortion. So we may use analogies by saying, if this factor is similar with respect to impact on a similar value, then the solution should be the same. So it's possible to accommodate analogical reasoning within this model.
Thank you very much, Professor Giuliano. Now you have the floor for 1 minute for final words.
No, just like to invite you again to read the paper, and we still are investigating this issue. One of our goals is in future work to explore situations where we compare different actions, because this model is applying to one action at a time. So all the functions are indexed to a particularly given action, but now we would like to compare different actions in terms of their impact on aggregate impact on values. So thank you very much.
Thank you, Professor Giuliano. Thank you, Professor Adelcio as well. Now, I would like to present again for the second time today, directly from Japan, Mr. Wachara Fungwachara Korni, with the replay of the paper on semantics-based minimal revision for legal reasoning. Mr. Wachara will replay his video from this morning, and then he will be available to answer questions from the audience.
Greetings to you all. So this work is a work that I work with Assistant Professor Kane Jishima and Professor Ken Sato, and we are from IAAIL and Sokendai in Tokyo, Japan. So this presentation is divided into 4 sections and shown here. So let's go, let me give some background of this work. So in this work, we consider the problem that the literal interpretation of statutes may lead to counterintuitive consequences. Which are the counterintuitive consequences are the consequences that do not meet the social expectation and the consequence occurs since the social expectation is evolved or exceptional cases happen unexpectedly in real life. So this kind of consequence cause absurdity, strange behaviors, or leads to public interest if the consequence were not properly handled. So judges, especially in high courts, may handle this kind of consequence by considering the exceptional situation of the case and make a legal judgment known as the case law that divides the interpretation of the statute to handle the exceptional situation. So in this work, we consider minimal revision. This is one common criterion from the standard revision theory. We reset it to adjust theories as little as possible. So minimal revision can be divided into 2 main types. The first type, as we call syntax-based minimal revision, is to keep the set of rules as close as possible to the original one. So this type of minimal revision is independent from the facts of the case. And the second type is a semantics-based minimal revision, which is to minimize the change of the set of conclusions obtained from the theory. So this type of minimal revision depends on the facts of the case, since different facts give different sets of conclusions. So although the syntax-based minimal revision is benefit from the independence of the facts of the case, we argue that the semantics-based is more preferable in legal listening. Since legal listening is a hybrid listening between rule-based listening and case-based listening. So therefore, we propose here one kind of semantic-based minimal revision called a dominant-based minimal revision. So this solves some problems in attempting to develop a semantic-based minimal revision. So let me give some settings of this work. So in this work, we consider a normal logic program also known as a log program for representing the schedule as its many previous works. So a normal logic program, here after a program in short, is a set of rules in the form of head, if, the bodies, where the body is divided into two parts. The first part is the positive body, and the second part is the negative body containing the negations, where the negations here, it shall be interpreted as negation as failure. So in civil litigation, a judge would make correspondence between factual situation in the case and factual concept in schedules. Then the judge would conclude a legal decision based on the schedules. So to reflect this civil litigation, we determine propositions into two types. The first type is rule proposition, and the second type is fact proposition. So the fact domain is a set of all fact propositions in the language, and the case is a subset of the fact domain. So we define the fact base and the rule base as shown, and we get that the answer set is the set of conclusion from the union of the fact base FB with a rule base RB. So this represents the literal interpretation of the statute, which is represented as RB when applying in a particular case that's represented by FB. So we denote a proposition P is in the answer set of FB union RB by FB union RB derives P. So exceptional case is a case that the judge disagrees with the literal interpretation in the case, and the judge introduced a new factual concept to distinguish the case as exceptional. So we formalize the agree and disagree as follows, saying that FB1, the fact that FB1 union with the rule base RB1 agrees with the fact that FB2 union with the rule base RB2 on some proposition P if is derived in the same, they derive in the same manner, or they do not derive P in the same manner. So otherwise we say that if B1 union RB1 disagrees with B2 union RB2 on P. So now we can formalize a counterintuitive consequence resolution task, or CCR task in short, which is the tuple of RB, FBE, and P, where RB is a rule base representing statutes, and FBE is a fact base representing exceptional case, which contain at least one new fact proposition not occurring in RB. So P is a rule proposition representing the considered counterintuitive consequence. And we call some rule-based RB prime is as a resolution to the CCR task if FBE union RB prime disagrees with FBE union RB on P. So this implies the counterintuitive consequence is resolved, the P1. So let's state with the example. Let the fact domain be the set of ABC, and this is the simple rule base of P if A, Q if P if Q, Q if A, Q and Q if B. So suppose P here is a counterintuitive consequence, and we apply this exceptional from applying this rule base in an exceptional case represented by the set of AC. Then we get that there are many resolutions to this CCR task. One is to add the exception not R in the first rule like this, and then we add the rule R if C. And then the second way is to add not R in the second rule, and we add the rule R if C. both are the resolution to the CCR task. So we use the concept of a cockpit in digital debugging to specify which rule should be an exception, which is not to be put in. So for example, we say that RB2 aims to resolve the cockpit P because it adds in not R in the supporting rule of P, while RB3 it aims to resolve cockpit Q since it's added in the supporting rule of Q. So we consist this kind of semantics of a rule base and the semantics minimarization. So we consider semantics of a rule base RB as a set of all pairs between the possible fact base FB and the answer set of FB union RB. So for example, this is RB1 and RB2 from previous slides. So we get this kind of possible fact base that interpolate from the fact domain of ABC. And then we have the answer set of corresponding to the rule base RB1 and the rule base RB2 as shown here. So we get that the symmetric difference of this answer set would contain R if the fact base contains C, because the new rule is R if C. Therefore, we have R in all such fact base, and the set of C, the set of AC, the set of BC, and the fact base of ABC. So to eliminate this kind of effect, we consider partial symmetric difference with respect to some set. So as per the set of P here. So we create the intersection between the given set and the symmetric difference. Then we get that there are three rows. In this example, there are three rows such that it contains the set of P as this partial symmetric difference. So for another example, as we have the RB3 that add not R in the second rule instead of the first rule. We get that in the same manner, we get the partial symmetric difference only in the row that's correspond to the fact base FB as AC. So we can see that RB3, this kind of RB3 has a smaller change than RB2 from the original rule base RB1 with respect to the set of P. And it seems that RB3 is a semantic based minimal revision with respect to P, the set of P, among all the solutions to the CCR task. So if we would like to have the smaller change than this RB3, we need to make this law to be empty set. But to make such thing, it make that it's not a resolution to the exceptional case of AC anymore. So we can consider RB3 as a semantic base, it seems. However, there are two problems in such definitions of minimal revision. First, it is exhaustive to interpolate the answer set for each fact base. And the minimal revision is broken when the fact domain is extended. So let's make it with the example that suppose we extend the fact domain in the previous example to the set of A, B, C, D. Then we get with following tables. And we get that the row that have non-empty set within the set of P in this case contains in the row corresponding to the fact base AC and also ACD. So it's guys that there exists a resolution, some resolution RB prime that have smaller change than RB3 by instead that such RB prime would have no change. So this row will be empty set as it then. However, we consider such resolution RB prime to be too specific because we need to change two times. The first one is to change corresponding to AC, and we need to reverse back in the fact base ACD. So to solve this problem, we consider that each fact base has a corresponding specific rule base and dominant rule base with respect to the considered constraints. So we say some subset SR of ARB is of whole loop base RB is specific to the fact-based FB with respect to the whole loop base RB and on position P. If SR is a minimal subset in the sense of set inclusion, such that if we union with such SR with the given FB disagrees on the union the whole loop base RB with such FB on P, and no intermediate loop base SR palm such that is in between SR and RB, and FB union SR palm disagree with FB union SR on P. So specific loop base might not be unique, and if we have some specific loop base, set of specific loop base, we say that a dominant loop base is such set of specific loop base but removing the negative body of the loop. So let me illustrate with the example that we have the loop base RB1 and RB2 as previously illustrated, and we say that the dominant difference of the dominant base semantics is considered by the pair of dominant loop base changes, regardless how many fact base would dominant loop base are changed in that way. So for the example of RB1 and RB2, we get that there are 3 patterns that have been changed. So as shown here, the first these 3 rows. So for another example that we have RB3, where the second not R is added in the second row, we get that they have only 2 patterns that have changed. One is the pattern of the corresponding to the fact-based AC, and another is correspond to the fact-based ABC. So this pattern also although it was same when we extend the fact domain. So if we extend it to ABCD, we will have the same pattern here, but we does not count how the fact base is, but only count the patterns, so that this kind of difference is independent from the extension of the fact domain. So to obtain this kind of dominant loop base, one way is to extend the body of the new rule so that it influences the dominant loop base as least as possible. For example, if we suppose we would like P is as a culprit and we add not R in the first rule, then the way to make minimal revision is to extend AC the new rule as R if AC instead of R if C. Then we get only 2 revision that only 2 changes that in the rows.
Mr. Bhattara, 5 more minutes, please.
Right. So given a CCR task, let me illustrate with the working example that given a CCR task of JRB1, JRB1, which is the rule-based represent Japanese Civil Code Article 612, and this talk about the cancellation of the lease contract due to the subleasing without permission, and this to prove that the cancellation due to sublease, we need to prove 4 requisites. The first one is the lease contract must be effective. The second one is the sublease contract must be effective, and the third one is the listing use, and finally the cancellation is manifested. And there is one exception that is sublease has been approved before cancellation, then cancellation due to sublease shall not be valid. So this effective contract has one rule R2, but the effective sublease contract suppose that there are 2 rules R3 and R4. Yeah, so there are 2 types of effective sublease contract. And this one exception rule about the approval of sublease here in R5. And we have the exceptional case that have this kind of 6 facts, which literally make cancellation due to service to be valid. But the judge indicates the facts about non-destruction of confidence as an extra fact, and would like that and did not intend that cancellation due to service to be valid in this case. So the cancellation due to service is our counterintuitive consequence here. So one way to revise to have the solution of this is to add new exception, while the new exception is derived from non-destruction of confidence, the extra effects. However, we get that this JRB2 will make a necessary change to the dominant rule base of the relevant case that with the both case of sublease, a second kind of sublease, since it will execute the exception as shown in this table. So another solution is as shown that instead we have the new rule of exception that derive from these three conditions. So when compile this kind of rule base and fact base and execute this dominant rule base, we get that the dominant rule base of this kind of this JRBT does not make unnecessary change occurring in JRB2. JRBT is actually a dominant base minimal revision. Usually, this new rule for the new exception box auto type of sublease and allows only the type of sublease that relevant to the present case. So let me have the conclude of this presentation that in this work we propose a dominant-based minimal revision is a kind of semantics-based minimal revision, and this solves two problems in attempt to develop semantics-based minimal revision. One is this is not required to calculate the set of all conclusions for each case and is unaffected by the fact domain extension. And in further, we would like to develop effective algorithm for finding such minimal revision and make applications for other type of legal representation and other type of revisions and application for the case where the revision impacts several rules. So we hope that this minimal revision may lead to impact analysis in legal formalisms and may contribute to improving coherence in law. So this is the end of the presentation. Thank you very much for your attention. I look forward for the question. Thank you very much.
Thank you, Mr. Wat.
Mr. Wachara, thank you very much for your replay. Now we have a few questions from the audience. Okay, the first one from Mrs. Judith Garcia. How can we define a counterintuitive consequence?
Right. Thank you very much for the questions. So in this setting, in this work, we consider the setting called the legal debugging, which we assume that a legal listening system derives consequence from the literal interpretation, and user works as an oracle query of an unknown set of intended interpretation, and we determine a counterintuitive consequence is a consequence in the symmetric difference between consequence of literal interpretation from the system and the consequence of the intended interpretation from the user. So that is the brief definition of counterintuitive consequence. And we call such thing legal debugging because we make iterations to ask the user whether the related consequence are counterintuitive consequence. And this is how we determine the things that are called the culprit, which is the root, which we determine as a root of the counterintuitive consequence, and that we put the exception in. So this is the definitions of counterintuitive consequence and the culprit. Thank you very much.
Thank you very much, Mr. Wachara. Now, are you able to answer a second question?
Yes, so I have the second question about
Can you read it for us, or would you like me to read for you?
So the second question that I have is, does the model proposed in the paper consider only counterintuitive consequence that arise from the literal interpretation of the rules, and also those that arise from other methods of legal interpretation? So if the answer is negative, is it possible to build a model capable of considering other methods of legal interpretation? So thank you very much for the question. It's interesting. First, we assume that the system, although we assume that the system represents a literal interpretation of the rules, but that is the primary presumption. However, if the user represent the system as any, it can represent the system and any application, any kind of interpretation, so that such interpretation that reflects from the system, it shall be determined as one that we would like to say there is original interpretation, and the difference between intended one from the user and the one that obtained from the system is counted in this kind of counterintuitive consequences. So this is one way to formalize this kind of interpretation that we have, although it's not a literal interpretation, but it's one that has been represented in the as a rule base, and the one that we have intended in interpretation in the user's mind.
Thank you very much, Mr. Wachara. Now you have
very much.
1 minute for final words.
So thank you very much for your questions and comments. And I hope that I have received many recommended papers also. So thank you for that. And this is very interesting, and I will further read this paper theory. So thoroughly. So thank you very much.
Thank you very much, Professor Giuliano. Thank you very much, Wachara. Right next, we are going to have our keynote speaker of the day, Joe Cohen. And in a few moments, Mr. Aden will be here with us presenting Mr. Joe Cohen. Thank you very much.